Writing a legal brief can feel, well, pretty daunting. We tend to think of it as this long list of complicated rules you just have to memorize. But what if there's a better way to look at it? Not as a bunch of rules, but as a clear, step-by-step process for turning a dense legal argument into a story that's actually compelling. So let's dive into that workflow. This is the big question, isn't it? It doesn't matter if you're a veteran attorney or a first-year law student. Staring down that blank page is tough because the goal isn't just to be right on the law, it's to be persuasive. It's about guiding your reader, who, let's be honest, is a very busy judge, to your conclusion and making them feel like it's the only logical place to land. So in this explainer, we're going to do just that. We're going to turn that challenge into a simple, four-step workflow. We'll go from being the architect who lays out the blueprint for the whole argument all the way to being the artisan who puts on the final polish. It's a framework designed to make powerful writing a skill you can repeat, not just some random flash of genius. Okay, first things first. We're in the architect phase now. And honestly, the most important work you're going to do happens before you even write a single sentence of your brief. This is the blueprint stage. This is where you build the strategic foundation for the entire thing. This blueprint, it really just has three simple parts. First, know your reader. In this case, the judge. What do they need from you to make their job easier? Second, you've got to frame your issues with absolute precision. And third, order your points logically, from the most important to the least. If you get this part right, I'm telling you, the brief almost starts to write itself. And this slide just shows you the power of good framing. It's night and day, right? On the left, you have this weak, kind of vague question. It doesn't lead anywhere. But look at the right. That is a strong, logical path. It's like you're setting up dominoes. Fact one, fact two, and the question becomes the inevitable conclusion. You're not asking a confusing question. You're leading them to an unavoidable answer. All right, with our blueprint in hand, we shift from being the architect to being the builder. Now, the goal for this first draft is not perfection. Nope, the goal is momentum. It's all about getting the raw material, the core of your argument, down on the page without getting stuck in the weeds. This piece of advice is absolutely golden. You have to separate the creative active writing from the analytical active editing. You just have to. When you try to do both at the same time, that's when you get writer's block. So let your ideas flow, get it all out, and then, and this is key, walk away. Letting it cool off is what gives you the fresh eyes you need to come back and be a ruthless editor. And that leads us perfectly into section 3, refining. Now we get to put on our artisan hat. We take that raw first draft and we start to sculpt. We're sharpening sentences, clarifying points, and just cutting out every single thing that gets in the way of our core message. This is where good writing truly becomes great writing. Here is a super powerful target to aim for, and this comes from some of the best legal writing experts out there. Aim for an average sentence length of about 20 words. Why? It's simple, really. It reduces the amount of work your reader's brain has to do. Shorter, punchier sentences just make your points land with so much more impact. And here's the proof. Just look at the difference. The before sentence is just choked with what the source calls zombie nouns, those words ending in tation, and a bunch of filler. But the after sentence, it's direct, it's active, it's powerful. It doesn't just say the same thing in fewer words. It says it with way more force. So all of this builds into a really practical editing checklist. Think of it as your hit list. As you edit, your job is to slash the unnecessary legalese, kill those zombie nouns we just talked about, replace weak be verbs with strong action verbs, and cut all those filler phrases and throat-clearing intros. If you do this systematically, your argument is going to shine through. Okay, we've made it to the final stage, polishing. This is the artisan's final pass. The argument is solid, the sentences are clean. This last step is all about adding those professional touches that take your brief from just being competent to being undeniably persuasive. It's all about credibility and making a real impact. Your conclusion is your last chance to persuade, so don't waste it on some boilerplate phrase like that weak example. We've all seen that a million times. But look at the strong one. It doesn't just ask for a result, it grounds that result in fairness. It answers the why question. It reminds the court that the just outcome is also the fair one. And this, right here, is the soul of persuasion. Your credibility, your ethos, is one of your most powerful tools. Your tone should always be one of unflappable professional calm. You're the voice of reason here, guiding the court to the right conclusion. That kind of confidence, without any of the drama or hyperbole, is incredibly persuasive all on its own. So the real takeaway is this. A brief is so much more than just a summary of facts and law. When you craft it with a clear process, from the architect's blueprint all the way to the artisan's final polish, it becomes a powerful instrument of persuasion. It's a tool designed to get a specific result. The only question left is, how are you going to wield it?